Ready for dictation, start. On the question as to whether there was absence from work and no termination stop in the claim statement before the tribunal, respondent alleged that his services had been terminated and the manager has illegally dismissed him from service stop. Preliminary objections were filed by the appellant taking the stand that the reference was not maintainable since government could not have come to the conclusion that there has been termination of service stop. It was reiterated that there was no termination of service and it was still open to the respondent to resume work stop. This preliminary objection was filed on 7/11/1994 stop. On 21/2/1995, respondent filed a reply therein refusing to resume work stop. On 25/4/1995, the appellant filed rejoinder against the claim statement and again offered that the respondent could rejoin stop. Evidence was led to show that there was no termination of service and the respondent could join at any time stop. The tribunal in its award held that the termination was illegal and reinstatement with back wages was directed on the ground that even if respondent had started a betel shop, he could not be said to be gainful employed stop. Subsequent to the award, the appellant again offered respondent the option to resume duty pending challenge to the award in the writ petition stop. Respondent refused to resume duty stop. On 8/5/1999, as noted above, writ petition was filed before the High Court challenging the award stop. On 26/5/1999, High Court directed the appellant to deposit the wages with the tribunal and the respondent to report for duty stop. On 13/7/1999, appellant asked the respondent to resume duty and on 29/7/1999 deposited 50% of the back wages with the tribunal stop. Appellant requested the Deputy Labour Commissioner to depute an inspector with a direction to direct the respondent to resume duty stop. On 6/7/2000, the Assistant Labour Commissioner persuaded the respondent to join duty stop. The High Court dismissed the writ petition, holding that the termination was illegal and that the respondent had not been gainfully employed after termination of service because self-employment cannot be treated as gainful employment stop. In support of the appeal, learned counsel for the appellant submitted that contrary to this court's view, the court labor and the High Court have held that self-employment is not gainful employment stop. It is also pointed out that there was no indication in the claim petition that he was not gainfully employed stop.